Good evening, I'm Sharon, reporting on one of the most influential concepts in modern tort law, Lord Atkin's Neighbour Principle. The Neighbour Principle, established by Lord Atkins in Donahue and Stevenson, 1932, states that individuals must take reasonable care to avoid acts or omissions that they can reasonably foresee would likely cause harm to their neighbours, which means those closely and directly affected by their actions. This principle is significant because it redefined the duty of care in negligence law, extending liability beyond fixed relationships to anyone foreseeably affected by one's conduct. It introduced a moral duty based on foreseeability and proximity. It also shows the universal test based on fairness and foreseeability. Forming the foundation of modern negligence law, the Neighbour Principle continues to guide courts in determining when a duty of care arises in both English and Malaysian law. Now, we take a closer look at one of the most significant moments in legal history. Let us revisit the year 1932, when the landmark case of Donahue and Stevenson forever transformed the law of negligence.
On August 26, 1928, Mrs. May Donahue visited a cafe in Paisley, Scotland. Her friend purchased a bottle of ginger beer for her. After consuming part of the drink, the remaining contents revealed a decomposed snail. Mrs. Donahue suffered severe gastroenteritis and shock as a result. Crucially, Mrs. Donahue did not purchase the drink herself. Therefore, she could not sue the manufacturer under contract law. Hence, she filed a claim against Mr. David Stevenson, the manufacturer of the ginger beer, alleging negligence in the production and bottling of the drink.
Earlier, we examined the story behind Donahue and Stevenson, a landmark case that transformed the law of negligence. To help us to understand its key issues and the significance of the judgment, let's turn out to our legal scholar, Miss Evelyn. Could you outline the outcome of Donahue and Stevenson and explain why it remains so important in negligence law?
Certainly, the House of Lords ruled in Mrs. Donahue's favour, and this judgment established the modern tort of negligence. It introduced the neighbourhood principle, which means a person owes a duty of care to those who are closely and directly affected by their actions. This outcome was groundbreaking because it recognized liability even without a contractual relationship, creating a general basis for consumer protection and liability for carelessly causing harm. Donahue and Stevenson still remains the cornerstone of negligence law today.
Thank you, Miss Evelyn, for that insightful overview. Next, we'll continue with the talk show sessions featuring our two speakers who will share their views on how neighbor principle evolved in English law through key cases and judicial interpretations. Good morning, Miss Sarah. Could you walk us through how the duty of care developed in negligence law, starting from Donahue and Stevenson?
Of course, the tort of negligence applies when a claimant suffers injury or loss because the defendant failed to take reasonable care in a situation where a duty of care is owed. To succeed in negligence, three elements must be proven: a duty of care, a breach of duty, and the damage caused by the breach. The modern duty of care was established in Donahue and Stevenson in 1932. Lord Atkin introduced the neighbour principle, stating that we must take reasonable care to avoid acts or omissions that could foreseeably harm those closely and directly affected by our actions. This principle broadened liability beyond contractual relationships and became the foundation of negligence law.
As Richard Castle observes in his journal, Lord Atkin and the Neighbour Test, Origins of the Principles of Negligence in Donahue and Stevenson, the liability for negligence, whether you style it such or treat it as in other systems as a species of culpa, is no doubt based upon a general public sentiment of moral wrongdoing for which the offender must pay. This reinforces that Atkin's principle was not just a legal innovation, but rooted in moral responsibility, showing why it became such a powerful foundation for negligence law.
As the tort developed, courts faced the challenge of limiting claims to prevent the floodgates of litigation. Lord Wilberforce's two-part test in and Merton, London Borough Council in 1977 asked whether there was sufficient proximity and whether policy reasons should restrict liability. However, this test was criticized for being too wide, and in Caparo Industries PLC and Digman in 1990, the House of Lords replaced it with a three-part test: foreseeability, proximity, and whether it was fair, just, and reasonable to impose a duty. A more recent case, Robinson and Chief Constable of West Yorkshire in 2018 clarified that the Caparo test does not replace established duties of care. In that case, police officers injured a bystander during an arrest, and the court held that the police owed her a duty of care. The judgment confirmed that public authorities can owe duties to individuals when carrying out operational decisions.
As the Oxford University Research Archive notes, duty cases, the Supreme Court held, are to be decided by reference to precedent where applicable, or where no such precedent applies, by analogy with the existing authorities. This approach curtails the role of policy in the duty of care inquiry. This supports my point that Robinson shifted the focus back to precedent and incremental development, limiting broad policy arguments. It shows how the neighbor principle continues to influence modern duty of care reasoning, but now through established case law rather than abstract tests.
So, from Donahue and Stevenson to Robinson's case, we see how the duty of care has evolved, balancing fairness to claimants with limits to prevent excessive litigation. This development remains central to negligence law today. Thank you.
Thank you, Ms. Sarah. It seems that the neighbor principle has been expanded. Ms. Megan, could you explain how the three-part test from Caparo and Digman shaped the law of negligence?
In Caparo, the claimant relied on audit reports which stated the company was running at a profit when investing in shares, but the company was actually running at a loss. The claim failed because the auditors did not owe a duty of care to the investors because there was no sufficient proximity, and the reports were not prepared for that purpose. The case has marked a turning point, moving away from the broad foreseeability approach of Donahue and Stevenson. So in this case, the court has established three requirements to establish a duty of care. First one is reasonable foreseeability, second is proximity, and the third is being fair, just, and reasonable. In the first element, harm must be a foreseeable result of the defendant's conduct. For example, in Borhill and Young, no duty was owed because the harm by the bystanders was not foreseeable, while in Haley and London Electricity Board, the court held that blind pedestrians must be considered foreseeable users of the street. In the second element of proximity, there must be a sufficiently close relationship between the parties, whether physical, relational, or causal. In the case of Hill and Chief Constable of West Yorkshire, the police were not liable to the victim's mother because there was no sufficient proximity between them. And the last element is fair, just, and reasonable. Courts consider policy factors. For instance, in XA and YA, it was held unfair to impose liability for a mother to fail to prevent her child's abuse. Although the test has been criticized for uncertainty, the courts clarified in Robinson and Chief Constable of West Yorkshire that Caparo is mainly applied only in novel situations. Where precedent exists, established principles will guide the duty of care. So, Caparo and Digman remains a key authority, ensuring negligence law develops incrementally and within fair limits, balancing foreseeability with proximity and fairness.
Thank you to our speakers for sharing about English law. Next, we'll continue with the Malaysian perspective to understand how neighbor principle is applied in Malaysian courts.
There are three main sources of law governing tort in Malaysia: principles of law being codified as statute, local judiciaries, as well as English common law. Under Section 3 of Civil Law Act 1956, it provides that if there is a lacuna or gap in Malaysian law with regard to local circumstances, English common law and rules of equity as administered in England after 7 April 1956, 1st December 1951, 12 December 1949 are persuasive to courts in West Malaysia, Sabah, and Sarawak respectively. Any law established before that are binding.
So, my first question for the Malaysian team is, how does Malaysia govern tort law?
So the development of the neighborhood principle branched into two categories, which is the application of foreseeability without proximity and the application of the three-stage test. In the case of Satu and Hawthornden Rubber Estate Co. Limited, the facts of the case is the plaintiff's cattle strayed onto the defendant's rubber estate and were injured, and the plaintiff claimed the defendant was negligent in not preventing the harm. However, the court held that there was no duty of care, and the court found that it was not reasonably foreseeable that the plaintiff's cattle will stray onto the defendant's estate. In the case of Dr. Abdul Hamid Abdul Rashid and another, and Jerusalem Leisure Consultants and others, the facts of the case is the plaintiff hired the defendant to do construction on his house. However, several years later, the house was built and it began to collapse due to a landslide, and the plaintiff was forced to evacuate. The plaintiff brought the case in court against the defendant for erecting the house on the neighboring land. So the court held that the defendants were liable because it was reasonably foreseeable because the engineer's recklessness has caused damage to the house of the plaintiff. In Malaysia, it shows that foreseeability alone is sufficient enough to impose a duty to the defendant.
Oh, I see. So, when do you use the neighbor principle and the threefold test?
In the case of Uniform Sendirian Berhad and Chin Bun Lit and another, Malaysian courts have finally implemented the threefold Caparo test, which incorporated Lord Atkin's neighbor principle, considering both foreseeability and proximity. In this case, the plaintiff was a manufacturer and operator of public telephones using telephone cards, while the defendants were the editor and the proprietor of a newspaper. The defendants published an article in the Post explaining a detailed method by which discarded telephone cards were used to make free phone calls. The plaintiff contended that the defendants, by publication, has breached their duty of care to the plaintiff, causing damages to them. The court held that students have already been using the discarded phone cards to make free phone calls, so it would not be fair, just, and reasonable to impose a duty of care because the damage was already done.
The late Professor Nur Chaya, who is a legal scholar, has given a comment to this test for the duty of care. So she said that if the plaintiff suffers physical harm, the foreseeability test alone is enough to establish a duty of care. And if the defendant could reasonably predict their actions might physically harm someone, that is sufficient. And a fair, just, and reasonable test is only needed when the court has to decide whether it's appropriate to impose a duty in complex situations.
For example, in a case where the plaintiff has suffered pure economic loss, would it be fair, just, and reasonable to impose a duty of care to the defendant? In Malaysia, the Federal Court ascertained the use of the threefold Kaparos test in Majlis Perbandaran Ampang Jaya and Stephen Hua. The Federal Court considered whether it was fair, just, and reasonable to impose duty of care to MPAJ. The case of MPAJ and Stephen Hua remains as the starting point to determine duty of care in Malaysian cases concerning pure economic loss. The material facts of each cases will be examined to decide whether duty of care would be imposed to the defendant. There might be questions concerning how duty of care is determined in cases of professional negligence. In situations where doctors and their patients are concerned, neither the neighbor principle nor the threefold Kaparos test should apply to determine duty of care. Duty has already been established in a doctor-patient relationship referring to Crown against Bateman in 1925.
That is all for our talk show. Now we'll be diving into the critical analysis of the neighbor principle. First, we'll be talking about the advantages and disadvantages of the neighbor principle, as well as we'll be doing a comparison of the English and Malaysian approaches of the neighbor principle. There are three advantages of the neighbor principle. The first one being the foundation of modern negligence. So the neighbor principle has given like a general basis that courts can use, like a general test that courts can use to sort out cases regarding negligence. So it was later applied, this neighbor principle was later applied in cases such as Home Office and Dorset Yard. Moving on, the second advantage is broad applicability. So courts can apply the neighbor principle in various situations such as economic loss, professional negligence, as well as psychiatric injury. And the last advantage of using the neighbor principle is it promotes fairness and justice. So it protects those directly affected by someone's negligence or breach of duty despite not having a contractual relationship between those two parties. Now, moving on to the disadvantages of the neighbor principle. The first disadvantages of the neighbor principle is that the term neighbor is too broad and uncertain. So these may open doors to floodgates of litigation, but then it was later overruled by the Kapoor's test, which imposed foreseeability, proximity, as well as fairness. The second disadvantage of the neighbor principle is that it is very inconsistent. So the meaning of the term reasonably foreseeable may differ between judges and courts. Therefore, it may lead to inconsistent outcomes. And the last disadvantage of the neighbor principle is that it is not applicable in every scenario. What this means is that this principle may not be applicable in cases regarding pure economic loss. Hence, it is not really versatile in that sense. And that is all for the advantages and disadvantages of the neighbor principle. Thank you.
Now we'll be looking at the comparisons between English law and Malaysian law in regards to the neighbor principle. In English law, the neighbor principle was established in the landmark case of Donahue and Stevenson in 1932, where Lord Atkin famously stated that individuals owe a duty of care to anyone who is closely and directly affected by their actions. In Malaysian law, the principle was adopted in the Section 3 of Civil Law Act 1956, where it states that English law can be applied where no local law exists. Moving on, in English law, proximity and foreseeability are both required. Courts require a sufficiently close relationship between both parties. In contrast, Malaysian courts often emphasize foreseeability, like in the case of Government of Malaysia and Jumat bin Mahmud. Today, the neighbor principle remains the foundation of negligence. In English law, it is refined to the Kapara test, which balances foreseeability, proximity, and fairness. Whereas in Malaysian law, the principle is fully adopted, but with greater emphasis on foreseeability as the key determinant. In summary, while Malaysia has adopted the neighbor principle, it is applied differently. In the English law, they remain a balanced position, while in Malaysian law, they emphasize greatly on foreseeability. This comparison highlights how legal principles evolve across jurisdictions.
Welcome back. That's how a single case from 1932 continues to shape the way courts understand negligence today. Lord Atkin's neighbour principle remains the cornerstone of negligence law in both England and Malaysia. It introduced a universal moral duty based on foreseeability and proximity, transforming negligence into a doctrine capable of addressing modern social and legal challenges. Because of its broad scope, courts have refined the principle to prevent unlimited liability. In England, cases such as Caparo and Robinson established a more structured approach guided by policy and fairness. Malaysian courts have similarly applied these ideas while adapting them to Malaysian local contexts. Today, the neighbor principle undergoes not as a rigid rule, but as a guiding foundation, a living moral and legal concepts that continues to shape how courts define the duty of care. Thank you for watching Taylor's Law School News. I'm Sharon, wishing you a good night.